Hi friends from around the world. This is the journey of the European design system, and I will take you through two leftovers from the last video. The last video was on the filing, and there are two minimum requirements, the languages and the goods, which I want to go over. Minimum requirements, so it is quite important that you know what is here on the line. Languages. The languages, that is the same regime more or less with the trademarks. So we have 23 languages, right? You know this from the European Union, and we have 5 working languages at EU IPO, which is English, French, German, Italian, and Spanish. You need to indicate in the form a first and a second language. The first is for the communication between you and the office, excuse me, the EU IPO, and the second language is one of the 5 languages, the working languages of the office, as I said before, and this is for the proceedings of inter partes proceedings. So there's a third party, the invalidity applicant, for example, and you and the office, so that is with regard to the second language. Now, when there's an exception with regard to it, and I come later to a concrete case of it. Well, this is where you have, for example, 2 Polish companies, one and the other, the design holder and the invalidation applicant. They are 2 Polish, and they have Polish lawyers, so they could easily take their proceedings in Polish. So if they agree on that and they request to the office that they want to have the proceedings in Polish language, the office would follow suit. So they would make the proceedings in Polish language. In that case, we will see in a moment, this has not been requested, so the case was in English. This is on the language regime, minimum requirement. The second is the goods. Goods, not goods and services as the trademark. We have here the designs, the products, physical issues, so they have a shape, and services, they don't have shape. But goods, also here in the form, you have to indicate the classification of the goods, and that is not the classification of the NIS classification trademarks, it is Locarno classification. The Locarno classification has 32 classes and more than 200 subclasses. So is it very difficult? No, it's not difficult. It is made easy for you. On the Euro-Locarno database, which is on the EU IPO website, there you can look up all the different terms in the different classes, and you can pick what suits you with regard to the goods, to the products you want to cover with your design registration. And the goods are not as important as in trademark. And as in trademark, you know, if the goods or services are not similar or not identical, well, there's no likelihood of confusion. Here, the situation is different. In design right, the goods are not as important. There's no requirement for any invalidity, for the success of an invalidity proceeding, that the goods must be similar. They can be identical, but there's no material impact on the overall result. We will see this in a moment. So this is about the goods. The goods, what is its importance then, or why is it necessary to put the goods on here? Well, it is for administrative reasons, but it is also, you can use it to your advantage. You may remember the due diligence I insisted much about in a previous video. You have to do to build a solid foundation for your design registration. How can the due diligence being done? I talked you through the design view, and the design view, there are many designs out there, and not only designs, can be an earlier right which may threaten your design registration. So there is a lot of them, and in order to narrow them down, the potential threat, you have 2 measures, 2 search criteria. One would be the goods, so the goods according to the Locarno classification, and the other would be the Vienna codification, which is with regard to the shape of your product. And then you can narrow down and look what's left in order to see whether there's something you have to worry about with regard to what is already on the market. Does that make sense for you? Let's go to the next issue here. We have 3 concepts to go over. One would be the informed user, the second would be the freedom of the designer, and the third would be what the individual character that is within the overall assessment. And I have prepared a case for you. Here's the case. It is the case from the Boards of Appeal, a recent case, so from September of this year. Boards of Appeal meaning that is a second instance. You have an examiner, the design department, so on the first instance, and the second instance, Board of Appeal, and then you go to the judicial court if you want. And the decision is about precisely these 3 concepts, although I made it quite easier. So nearly all the decisions, they are about what we have talked already, which is it a sign which qualifies for invalidity application? Is it an earlier sign? Earlier must be earlier. Is it disclosed? Yes. And if it is closed, then is it in the normal course of trade that the design holder should have known it? We have talked about this. And this here is cleared already, is out. So I will not go over this here in order not to repeat myself. So let's look at the signs if you want. Here are the signs. On the left we have from a Polish designer, and we have 7 representations, clean representations, so it's all good. It seems okay from the examination point of view. And on the right side we have a US patent also from a Polish company, which is earlier, which has been disclosed because it is on a patent register, and it could not be refuted with regard, so not be known by the design holder. So that is all okay. Now, with regard to the decision has 2 parts. One part is about the arguments and the facts of the case, and the second part is about the reasons. It is more or less 50-50, but it may differ in a case where you have a lot of legal problems too, or you have, on the contrary, a lot of facts, but normally it is quite 50-50. Let's go to the reasons and to the informed user. That would be point 21. So you have always points here in the decision. Each paragraph corresponds to 1 point. And point 22 is the informed user, is about the informed user. What is the informed user? Well, informed user is the equivalent to what is the average consumer in trademarks. But it is still very different here. The average consumer is somebody who goes into a retail store and would look for, I don't know, a can of food or so. That could be anybody. Whereas here, you see this in text block 22, a text block. They are using it in decisions very often. A text block is what would be settled case law as a background, and the basic concepts are clear because they have been judged over and over again in the same sense, and this is made clear by certain text blocks which you find in all decisions. So the informed user standard would be the one against which all the overall assessment has to take place. It is a fictive person, so it is just as trademark, a fictive person. It is not the examiner who has its own opinion. It is the examiner who has to step into the shoes of this fictive person. And what is this fictive person? According to settled case law, an informed user is a person without being a designer or expert. It is familiar with the different designs on the market, with a high degree of attention which he pays to each design. And point 23 then makes the point with regard to roof tilings. Both signs, by the way, are designated for roof tiles. And it makes the point that this informed user knows reasonably well roof tiles, and it goes even to specialized outlets and trade fairs. And even more, in point 24, it says, the Board of Appeal says that the informed user is, so to say, allowed, put into a situation where he can compare one and the other. So both conflicting signs, he can see them side by side. That is something very much different from trademarks. Do you remember, in trademarks you have to think of the imperfect recollection when you think of one trademark and the other mark. So this was about the informed user. Let's go now to the next concept, which is the freedom of the designer, and we have points 25 and 27 here on the screen. The 25 and 26 are again text blocks which you find in many decisions, and you have the corresponding case law indicated there for your review if you want to do so. Now, what is the freedom of a designer? We didn't talk about this concept so far. What is that then? Well, take the situation where you have a possibility to have a lot of freedom of design. There are no constraints with regard to the technical function, so the issues, the parts you can see of the design are not determined by the technical function of the product you are about to file, but you have a freedom there, and you have a freedom with regard to statutory requirements, so regulations or so from the government. So you have the designer, they can display its creativity freely. Then the informed user, we come back to the previous concept, the informed user, they would easily distinguish one and the other, and he would not look much into the details. Whereas on the contrary case, you have a design where the user, where the constraints are very strict, so you have a lot of technical function pieces there, and you have regulatory requirements where the pieces have to be in certain places, then it would be only possible for the informed user to go very into detail in determining which is one and the other. So it has some implication with regard to the overall assessment, which then comes logically afterwards, right? So we have these text blocks in 25 and 26. You may read them in detail and the corresponding case law. And 27.27 applies the concept to the roof tiles, which are the ones in that case. And it concludes that for this kind of products, the designer has a certain degree of freedom with regard to the shape, the size, and the arrangement of the pieces with regard to the design. Now let's come to the next point, 28. 28 is another text block. This is the overall assessment now. Now on the overall assessment, which is, so to say, for you easily to remember, it is equivalent to the likelihood of confusion, but it is not. That is somehow different, but it is about to determining whether the design is to be rejected or not. is a text block with settled case law, but it is a bit, individual character, overall assessment. It comes down to this. If there's a different overall impression, then the contested sign has individual character. If there is the same overall impression, then we have no individual character of the contested sign. Do you feel me? Is that clear? Or you can say in another way, individual character is when the designer comes across this new design and says, wow, I've never seen this. So déjà vu, right? So this would be what can be, in similar terms, in simple terms, be explained as individual character within the overall assessment. And now let's come to the signs again. You remember the signs? Here they are again. On the left we have the design as registered. On the right we have the US patent. What do you think? What will be the outcome of the case? How would the case being judged in your home jurisdiction? I would be very interested in how you would think in your home jurisdiction to settle this case. And if it is, if at the end it is the same, you can very comfortably advise your client on European design rights, okay? So these are the two designs which we have here. And then we have with the point number 29, we have now starting the comparison of the sign by the Boards of Appeal. It starts with 29, where it says simply there are some similarities or identical features, but they say in 4 consecutive points, so 30 to 33, they say, well, it is all about the differences. So the Boards of Appeal, they go through the differences very detailed and list them all up. So I will not go through these differences. You can read them and look them up. I think it would not be impossible to come to a different conclusion, but I'm not sure how you would see that. Would you see the differences are so big that the informed user, those not experts but very reasonably informed people, will distinguish between one and the other? Well, this is not exact science, so we will just leave it as it is and see other cases in the future. So let me wrap this up. We have gone over these 3 concepts. One would be the informed user. The informed user is somebody very knowledgeable about the goods of what is the case in each time, right? In each case. And you have the freedom of the designer, which can be very large or it can be very narrow. And then you have the overall assessment, which determines whether the contested design has individual character or not. So that is now the important lesson here. Thank you very much for tuning in. See you in the next video.